in sexual assaults that were covered up?
We covered technical edits yesterday, and those were edits where the staff and the committee members made edits, and those edits did not substantially change what was written. In most cases, or in all cases, it made it clearer to the reader what was intended. Yesterday, there were several times where we had to stop what we were discussing because it needed to be discussed or deliberated in the public forum, in a public meeting today. So when we get to those points, I will turn it over to the chair, and then she will discuss and handle that discussion. And after you all come to a consensus or don't come to a consensus, we'll have a vote for what is going to go into the final report. So we'll start with the table of contents and page 1, and the edits that were made were approved by General Schwank. And if we move to page 4, once again, those edits were approved yesterday because they didn't have any substantive change to the report. Now we're on page 6. And once again, we have no substantive changes to the report, just technical edits. Page 8, we added a staff footnote, and that was just to clear up what was going on in the paragraph that it was discussed. Page 9, once again, General Swank approved the staff edits, and we added his information into the report. On page 10, we added a footnote to clear up any ambiguity in the previous, that footnote clears up. So we go to chapter 1, which is on page 11. And chapter 1 is findings and observations based on the review of MCIO, those are military criminal investigation organizations, penetrative sexual offense investigative case files closed in fiscal year 2017. And so we look at page 11. General Schwank had a comment. I think we approved, or yesterday we went over that comment, and he had no further issue. On page 12, we have one technical change. And throughout the report, you will see this change. So I'm not going to cover it every time that we go over it, but we changed the word sexual assault to sexual offense. So for consistency throughout the report, that's the term we'll use, as sexual offense. Page 13, we had more edits, which we took care of yesterday. Same with page 14 and 15. We look at page 16. This is the first instance where the committee is going to have to discuss and deliberate. Ms. Garvin had a comment, and I'll turn it over to the chair to discuss the language that should be in the sentence that's in the first full paragraph. While some victims' counsel agreed to the follow-up interview, other counsel requested that the MCIO send written questions for the victim to answer, which is less than an ideal method for developing information.
Without the explicit statement of which is being valued. So what I was commenting on is there are lots of ways of developing information, and in a case-by-case analysis, there can be times when written questions are the most effective way for a particular person to respond to questions. But we're making a globalized statement here that it is always a less than ideal method for developing information. And so my question was, for whom, to what end, those kind of things, and not necessarily factoring that in a case-by-case moment, there are different ways of eliciting effective information for investigative purposes, depending on the person being interviewed and followed up with. So my recommendation was that rather than at this relatively early phase in some of our work, putting that assessment in, that we strike the clause. But again, I was not a part of the case review process, so there might be strong feelings by the case review that that's a really important clause. So.
My thought on that is that unless you're dealing with a witness with some type of disability, written questions then get sent someplace. They get answered, they get sent back, which really completely curtails the ability to do follow-up questions. I mean, Mr. Kramer, if the government told you you could only communicate with your client by written questions, do you think you would get a full sense of what had happened?
No, obviously, right. I mean, obviously you're correct that I would never think of communicating with the client in writing. It's the primary.
Ms. Garvin, what if we added for the victim to answer, which, except in rare instances, is a less than ideal method?
So the value that we're putting on here is less than ideal method for law enforcement to elicit what they perceive as the full story. Is that, and
Yes.
The reason I'm flagging this is, right, so someone who's being asked questions, and again, was this that there would never be another moment for in-person questioning, which of course we know if it gets to trial there will be. So I get a first round of questions with you, and then let's say the SVC says, and I'm assuming that's where this came from, right, and based on the paragraph it is, said, you know what, I'm not going to have them sit down for an in-person again, because when they sit down with you, law enforcement, they actually start to have panic. Their memory becomes confused, and in fact, they're going to give you a statement that is less accurate because of the way X, Y, or Z has impacted them. And this is true of defendants too. I want to be clear about this, that sometimes our interrogation tactics do not factor the way the brain is working in the moment. And so what we actually are eliciting is less accurate and useful information from persons being interviewed or interrogated, whichever verb you want to use. And so either, for my comfort, I'd either want it to be, which is often less than ideal for developing information from a law enforcement perspective. That I would be comfortable with. But then we're at least putting the lens on of who is assessing that this is effective information.
With that friendly amendment, which is often a less than ideal method for developing information for law enforcement, from a law enforcement perspective, does anybody have any problem with that? So as amended, raise your hand if you're in favor, and Ms. Tokash and Judge Grimm, if you could simply say yes. Judge?
Yes.
Ms. Tokash?
Yes.
Okay, that's unanimous. Next.
Okay, thank you. We look at page 17. Those edits were handled yesterday. Page 18, the number 2 there under discussion, the last sentence in that paragraph says the word swiftly is used, and that seemed to cause some issues. So investigators need the ability to tailor the scope of an investigation to the facts of that case, including the ability to swiftly close investigations when appropriate. There was some discussion, but once again, it entered into the realm of deliberation, so in abundance of caution, we decided to discuss it today. There was some talk yesterday before we cut it off about just deleting that word. So I'll turn it over to the chair for discussion.
Does anybody feel strongly that the word swiftly needs to be in there? I think what we're trying to address is the cases that really aren't making it out of the starting gate seem to go on for 6 months, but I think it would be fine if we say close when appropriate, because when appropriate will vary depending on an investigation. Ms. Cannon.
I think part of the thing that we wanted to address was the speed. And so I would just add a little twist to what you suggest to close the investigations as quickly as practicable and appropriate.
How about if we said the ability to close investigations in a timely fashion?
That's fine too.
Anybody have any thoughts about Mr. Kramer's proposed amendment
You're going to keep when appropriate?
in a timely fashion?
No, I'm sorry. It would say to swiftly, the ability to close investigations in a timely fashion or timely manner.
And keeping in mind, closing an investigation can be referring it for prosecution as well. It doesn't mean closing it down with no action.
Could you say timely and appropriate fashion?
Say again?
Timely and appropriate fashion to capture the general...
Timely and appropriate, in appropriate fashion.
Okay, so Judge Grimm has proposed that we say closing investigations in a timely and, I already forgot.
Appropriate.
Appropriate fashion. Anybody have any problems with that? Okay, in favor? Everybody present is in favor. Judge Grimm, Ms. Tokash?
Yes.
Yes.
Okay, that's unanimous.
Are Judge Grimm and Ms. Tokash raising their hands when they say yes, or are they?
And we're standing.
Thank you.
Saluting.
Okay, turning to page 19.
May I inquire? On page 18, did we delete a portion of the sentence before the one we just addressed where it said shape, the scope, and nature? Yes.
Yes, I believe yesterday we agreed that it would say, most case files revealed that investigators did not have discretion to pursue investigative steps that they deemed appropriate based on the facts of a particular allegation.
That was the technical.
And then also at the last paragraph on page 18, we decided to delete the agency that was mentioned. So turning to page 19, I have a question mark next to Ms. Garvin's comment.
That was removed yesterday. I withdrew it.
Okay, thank you. So there's nothing further on page 19. Page 20, those were technical edits made by the staff. Same with page 21. Same with page 22, 23, 24 and 25, 26 and 27, 28 and 29, as well as page 30. Page 31, Ms. Garvin had a comment that raised deliberation, and so it was in the second full paragraph there that starts, the DAC IPADG acknowledges. And I'll turn it over to the chair.
So the sentence that Ms. Garb was concerned about is the committee is most concerned. The question sentence is, the committee is most concerned about those cases reviewed in which the victim's preference to go forward to trial prevailed, even though there was insufficient admissible evidence to obtain and sustain a conviction. Can you tell us your concern?
Yes, it's actually with that very word, concerned. It's literally over that verb. Not having been a part of the case review working group, I am not sure at this juncture of our understanding of the cases that I am concerned. I am interested in further analyzing these cases and understanding whether there was a robust enough investigation that could have led to admissible evidence. But at this juncture, based on the testimony we've heard and the pieces I've been personally privy to, I am not concerned. I'm curious and I'm interested in further analyzing.
Thoughts from members of the committee?
I think that that's valid to raise, since we have some thoughts about whether or not we were able to review the complete record, even as given. So to flag it as something we need to go use a term that indicates we want to go back and look. First of all, to make sure, because I think this does reach the conclusion that there was insufficient evidence as a matter of the case versus that what we reviewed did not meet the standard. And we had talked about, and I know this will implicate something else, that we didn't always watch the interviews and there was other evidence we didn't see. We would just take the reports summarizing it. So I don't know what the verb is, though. But
Any other comments, suggestions?
It seems appropriate, the amendment. I don't have a problem with that.
I'm not sure what the amendment was.
Change concerned to interested.
Most
In
interested
further
in
analyzing. In further, in analyzing or further analyzing, because I am interested in digging in. There's clearly something we need to look at, but I don't feel like we've finished. So the amendment was that the sentence would read, the committee is interested in further analyzing those cases.
Yes, I agree. I think that's more accurate for what we're trying to get to.
So with that amendment, is the committee endorse that amendment? Everybody here says yes on the line?
Yes, no problem.
Yes.
That unanimously passes.
Okay, that was all that was on page 31. If we turn to page 32, there was just technical changes that we handled yesterday. Looking at page 35, it was a staff change. It's the first full paragraph there in blue, and the issue is halfway down in that paragraph, on page 33, excuse me. The implementation of the judge advocate consultation advice provisions of the new disposition guidance should be followed up on thorough site visits to ensure judge advocate advice is being conveyed to the initial disposition authority at a time and in an appropriate manner to inform the decision about what action, if any, to take on an allegation. The troubling word was ensure, and so I think that was, I'll turn it over to the chair to discuss what wordsmithing should be done to help the committee in that paragraph.
Yeah, I think ensure was, it's really not their job to ensure that the advice is, our job to ensure that the advice is being conveyed. I think it's more to see, just like to observe if the advice is being, to assess. Assess is wonderful, thank you.
To assess whether.
If we take out ensure and just add assess, does the committee think that that changes that's appropriate?
Yes.
Ms. Andrews?
Yeah.
I think you have to have the word whether there,
Assess
too,
whether.
right? Whether,
Assess whether staff judge advocate advice is being
Right.
conveyed.
Yes.
Okay, in favor? Okay. We already heard from Judge Grimm and Ms. Tokak.
So just to make sure that the staff is clear, meaning me, so that the word ensure will be removed and the sentence will cite visits to assess whether judge advocate advice is being conveyed.
Right, and
Okay.
that's not W-E-A-T-H-E-R, which you might think otherwise.
Thank you, sir.
You're welcome.
And that was all the changes on page 33. We looked at page 34, and the staff was going to add a footnote after that first paragraph, and we discussed that, so we'll add that in to the final draft. Turning to page 35, there were no additional comments. There were technical edits, which I mentioned earlier about conformity throughout the report. So turning to page 36, under observation 6, the sentence starts, the DAC iPad was troubled to see in some cases. The comment was troubled. Was that the correct language that should be used in that sentence? And I think this just is a wordsmithing change in that paragraph. So I'll turn it over to the chair for discussion.
I know, Ms. Garvin, you suggested curious. I'm not sure that curious really captures what we thought when a preliminary hearing officer said no PC, and yet charges were in fact referred.
How about has concerns? Or has concerns regarding this and would like to...
Further analyze, I mean, if we could go back to that language I'm okay potentially even with the has concerns here, as long as it's would like to further analyze, particularly in light of everything we've heard about how these hearings are going and what's happening in them. I feel like it's just the next investigative moment for us. So I'm not, I'm okay with, even in this situation, has concerns and would like to further analyze. I would be okay with that. I just don't want it to be a period essentially after the verb, which right, grammatically it kind of is right now. Sister Romanis, my 6th grade teacher, would be very happy that I'm focused on verbs right now. But so I agree. Okay.
What's a verb?
Conjunction, junction.
So let's see if this gets too wordy. The DAC iPad has concerns regarding cases where charges and specifications for a penetrative sexual offense were preferred
When?
That the preliminary hearing officer determined were not supported by evidence establishing probable cause to believe the accused committed the offense, period. The DAC iPad will continue to investigate this issue.
Would it be more proper to use the word where as opposed to that? Where the preliminary officer, hearing officer?
I'm agnostic regarding that. I said I'm agnostic regarding that.
Yeah, cases in which, I think.
So cases in which charges and specifications? Then continue on with that sentence, and then the DAC iPad will continue to investigate this issue?
I would be fine with that.
So could somebody read the whole thing as we've
The
revised
DAC
it?
iPad has concerns regarding cases in which charges and specifications for a penetrative sexual offense were preferred that the preliminary hearing officer determined were not supported by evidence establishing probable cause to believe that the accused committed the offense. The DAC iPad will continue to investigate this. Although, but then you interrupt the next sentence, which continues, the majority of these charges and specifications were not referred to court-martial.
To qualify the second sentence would be put at the very end.
So, and you would put that at the end of the paragraph?
Yes.
Sounds,
That works.
yes.
Yeah, thank you.
Okay, all in favor of that amendment? Judge Grimm, Ms. Tokash?
Yes.
Yeah, no problem.
So that passes unanimously.
Okay, moving down to the, almost the bottom, the last sentence in that paragraph that we were just working on, after footnote 110, the CRWG reviewers expressed concern in that paragraph. It was determined yesterday that that was one long, almost non-understandable sentence. So what the staff did was draft a potential, broke it down into more manageable pieces. So that sentence would read, CRWG reviewers expressed concern about cases referred to trial by general court-martial that the preliminary hearing officer had determined lacked probable cause to believe the accused committed a penetrative sexual offense. If such referrals were based on evidence not presented at the hearing, the benefits of the hearing's adversarial process were lost.
Is that a staff edit? Yes. Okay. All in favor?
I'm sorry, I apologize. Could you reread it, sir?
Absolutely. So, case review working group reviewers expressed concern about cases referred to trial by general court-martial that the preliminary hearing officer had determined lacked probable cause to believe the accused committed a penetrative sexual offense. If such referrals were based on evidence not presented at the hearing, the benefits of the hearing's adversarial process were lost.
Sir, that clarified it for me, and now I have my notes that I can read from yesterday, too. Sorry.
Okay,
Thank
so
you.
all in favor of that proposed edit? Judge Grimm, Ms. Tokash?
Yes.
Yeah,
Okay, that's unanimous.
All right, turning to page 37, we took care of those edits yesterday. And page 38, took care of that yesterday. Turning to page 39, observation 8, there was some discussion about the observation itself, which states, many sexual assault cases are being referred to courts-martial when there is insufficient evidence to support and sustain a conviction. And I believe, Ms. Long, you had concerns about using the word many in that observation.
I did based on the limits of our review, so my suggested language, I tried to revise by replacing many with, or inserting before many, based on information the CRWG reviewed in the investigative file. That's probably too clunky, but basically saying based on what we reviewed, we found this. But again, I think it's one of those, we probably need to look at it more deeply because we know our review is limited at times. That was my.
So I believe that, let me see if I have the sentence right, based on information reviewed, and that's before many. So it'd be based on information reviewed, many sexual assault cases are being referred.
Sir, what if we did it the other way, which is many of the sexual assault cases that were referred by the working group?
What about based on the CRWG's review, many sexual assault cases?
I just wanted to flag though, Chair, to flag in there that our review is limited, just so nobody draws a conclusion that it was true, given we know we didn't look at some things. That was my pushback, but if I'm the outlier, I'm happy to just be a dissenter on this.
Did we address what was in the case files earlier in the report that we did not either have access to or were able to review the tapes of the statements,
What
either
we
by the
stated-
defense or the witness?
What we've stated earlier is that our review by the Case Review Working Group was we reviewed those investigations that were provided to us and based our analysis on the case file that was presented, that was reviewed.
But that's really not the full picture, because if we didn't watch the tapes, which we didn't, then we didn't review what was given to us.
What if we put a footnote on that and down in the bottom referred back to the pages where we actually addressed that point, and also the other point about the limitations based only on the investigative case file, Steve Page, whatever, and then the one where I added that sentence about we didn't know, we relied, I think I said we relied on the investigators putting the key information into the summary, and we were upfront about that. That's what we did. So if we footnote to those 2 pages prior in the report, then anybody that looks at that and raises their eyebrows will look at the footnote, and then they'll read the other stuff, and then.
That's fine with me.
Okay.
So the staff will have to find that to footnote it. Is that fine with the committee as a whole? Referencing it that way?
Yes.
Ms. Garvin?
Yeah.
Okay, that passes.
Okay.
Or Tokesh.
Oh, I'm sorry. Sorry, Megan.
It's almost like you're not here.
Oh, my comments are coming.
Did you stand up? Did you stand up when you raised your hand? Oh,
Yeah.
sorry. It's okay. Anything I say.
That was all the edits or deliberation on page 39. There was no, those, on page 40, it was just technical edits. Moving to page 41, there was some comments about observation 9, and Ms. Garvin had a comment, so I'll turn it over to the chair for discussion. And
Yes, Ms. Garvin, can you tell us what your concern was?
Yes, the observation talks about that pretrial advice would be more helpful to, and this is quoting, to convening authorities if it included explanations of the staff judge advocate's conclusions. And that is, we had not yet, I don't believe we have heard from convening authorities telling us that fact. This is us assuming that it would be more useful to them, and I thought that clarification point might be useful so that it's not misconstrued as a testimonial statement based on facts, but that's my recollection.
What I remember we saw a lot was a checkbox. The forms, that we have jurisdiction over the accused, the forms and specifications are correct, and there was one more. It was like 3 checks. Jurisdiction, forms and specifications, oh, and probable cause. But it was a checkbox. So again, we're basing on what we saw in the file. I know we have heard in testimony that there's a lot of oral advice that's not documented that's given. But since it's not documented, we don't know what it is. Thoughts?
Would the word could as opposed to would solve the problem?
Absolutely.
Feeling?
So instead of the very last sentence of observation 9, we could say the Article 34 pre-trial advice could be more helpful?
Yes.
As amended, in favor? Ms. Tokesh, Judge Grimm?
Yes.
Okay, that's unanimous, and it's amended.
there was nothing else on page 41 that needed to have any discussion. Turning to page 42, Ms. Garvin had a comment that needs to be discussed.
Chair, do you want me to?
Yeah, can you explain that, please?
So my my reading of the final two sentences, and it mostly hangs on the clause of the last sentence. So the last two sentences read, the better practice is to provide, three sentences, to provide written explanations with further explanation as needed. A written legal analysis and rationale could enhance fairness, due process, and transparency in the military justice system. And then an M dash that says benefits that do not seem to be outweighed by a need for confidentiality. And it's that last, following the M dash, the benefits that do not seem to be outweighed by a need for confidentiality, that I wasn't sure we had enough evidence to make that statement. But again, maybe the working group got more information that they could share to explain that piece.
Thoughts?
We could just omit it. I don't recall that specific point of confidentiality being discussed.
I believe it was discussed when it was in a discussion about somebody tipping their hands, and the prosecution said, well, then the defense will know what we know, and the defense is like, we already know where you're going, and the prosecution already knows where the defense is going, something like that. But if we could just put a period right after system and leave out the anything after the dash, if that works.
Yes.
All in favor of that? Judge Grimm, Ms. Kalkash?
Yeah.
Okay, that's unanimous. Adopt.
Let's make sure. So a written legal analysis and rationale could enhance fairness due to process and transparency in the military justice system, period. Now we're moving on to Chapter 2, which is titled Article 32, UCMJ Preliminary Hearings and the Court-Martial Referral Process. There's nothing further on page 42 or 43, 44, 45, 46, 47, 48, 49, 50, 51, 52. There were changes on 53 that we discussed yesterday, and those were technical edits. Same with page 54, 55, and 56. Now, if you'll please turn to tab 5 in your materials. These are the charts that would go with the chapter. So what we needed you all to do yesterday when we came to these charts, I said, it's a lot to digest in 5 seconds that you're looking at them, so take a look at them tonight and determine whether or not you think if there's any changes that need to be made to them. And we discussed some quick changes to the charts, which was figure 1, where the 19, I think that was General Schwenk, the 19 was outside the box, and so the concurrence was that we would just move the numbers inside the boxes to make it more understandable to the reader. And that was the only change on that chart, and we had agreed to that yesterday, I believe.
Grade and rank.
Oh, right. Looking at
Excuse me. There was also a question with regard to the numbers on the left, 0 up to 30. Given the nature of the numbers in the graphs.
We were going to put something on the left-hand side that explained what that column meant, like total cases or something.
it doesn't match up with the well, yeah.
Scale is off.
I think when you add 9 and 19, that's 2 shy of 30, which is the graph. The confusion, I think, was when 19 was above it, because we all looked at 19 and saw it in the middle of the 30. I mean, if this chart is unclear or doesn't add anything, we can certainly delete it.
That piece is happening.
I think if you put those top numbers into the column, it will take care of that, because the lower numbers are in the column itself. So the 9 below the 19 is in there. It's making it look as though the total is 19.
We will redraft or rework this slide and get it back out to you, but
I've seen cases just like this where they put the 9 in the box, the 19 in the box, and they put 28 on top so that everybody sees there's the total 28.
Is that a change that everyone can agree to?
Yes.
Excellent.
I think it was good to think outside the box, though.
So we'll make those changes to that chart. Looking at the chart on the next page, we looked at the dark gray and the light gray, and the decision was made to merge those and made it easier to read and more understandable, since we were talking about dismissed by a convening authority. Is that everyone else's recollection to those charts?
Will we then use a medium gray for that? Or, never mind, I withdraw.
So we'll make that change. And then the same with the following chart. That's just a reproduction of the chart. It's fiscal year 17, and the next one's fiscal year 18. So we'll make the same changes on those charts. Any questions about the charts?
Can we go back to the round circle chart down in the bottom right hand? Said dismissed by the GCMCA and dismissed by the SPCMCA. Did we yesterday say we were going to merge those two?
Yes, sir.
Okay. So it's just going to say dismissed? Okay.
Okay. Turning back to page 58. There were no changes. Looking at page 59, the first paragraph, there was some discussion about whether it should be DOD or SAPRO, changing the wording there. So I'll turn that over to the chair for discussion.
Yes. General Schwenk, what did you mean here?
The sentence says the DOD does not collect information on the legal outcome of cases in which the victim is the spouse of an intimate partner. Then it goes on from there. And I just pointed out DOD does collect information on the legal outcome of all cases. And so it doesn't really matter who the victim is. DOD meaning the services as part of DOD. And I believe the people from the, or Chuck was there from the data working group, and he said that the DAC iPad gets their information that this refers to from the Sexual Assault Prevention and Response Office, SAPRO, in the Department of Defense, and that SAPRO does not. The sentence is true for SAPRO, which is where we get our information from. So it's my understanding that the proposal was change DOD to SAPRO, and if there was a feeling on behalf of the staff to explain that more, that's where we get our information from, you would do so. So that's...
Thoughts? I'm not sure SAPRO is where we get all of our information from.
Wasn't there an issue about FAP also not collecting that data?
Right.
So do we need to clarify that it's DOD, SAPRO, and also the family advocacy programs?
Yeah, we could say SAPRO and FAP don't collect it. I mean, they'd have to go to the services and have them pull through all their records to get the information.
Yeah, I just want to make sure we're clarifying that.
Okay.
I think the point is that for those years, 2012 to 2014, we don't have that information. We do have it for the following years.
That's correct, Chair. The reason, this is in the methodology of the data working, how the data came out. And so that's just explaining why the 2012 to 14 data is not as accurate as the rest of the data that we've collected for the case adjudication report.
Why don't we just say then, the statistical data for fiscal years 2012 through 2014 collected by the JPP do not include the legal outcomes of cases in which the victim is the spouse or an intimate partner,
Good.
and will not be included in the historical discussion to follow.
So the sentence that reads, "The Department of Defense does not collect information," would be deleted?
Yes, we would start out with the statistical data for fiscal years 2012 through 2014 collected by the Judicial Proceedings Panel do not include legal outcomes of cases in which the victim is the spouse or an intimate partner. Then you continue on to, and will not be included in the historical discussion to follow. Okay, as amended, all in favor?
Yes.
Yes.
If you could turn your attention to tab 6. These are the charts that will go in the report. And once again, the same discussion was had about giving you time yesterday evening to digest these charts. There's a lot of information there.
For the first bar chart on page 1, is that the total number of cases each year?
Yes, ma'am. It's the total number of cases that we have in the database at this point.
So do you need a title for that figure?
There should be a title that would be actually in the text for the heading for it.
Oh, it'll be in the text?
Yes, ma'am.
Okay. No,
There'll be a
that's,
table
yeah,
title.
that's not the right heading.
On page 59, down at the very bottom, it says figure 3.1, which I guess is that next figure. Cases documented by the DAC iPad. So that's the lead-in.
And the chart at the bottom of that page just breaks out once again the percentages of service members in each service and as a percentage of sexual assaults per service for the population. And if you look at page 60, it says figure 3.2, military service of the accused. And then the following tables provide an overview of the cases involving penetrative sexual assault, a sexual offense, and contact offenses completed by the military services in fiscal year 2018. Anybody have any questions or concerns about either of those charts on page 1 of tab 6? Moving to the next page, table 1, dispositions.
Colonel Laura, just note that it seems on page 62, we say table 3.1. And, oh, I'm sorry, it's the difference between figures and tables. That was duplicative. Anybody have any comments, suggestions? Good.
Now we're on page 66. No edits on 66. No edits on 66, 67, 68, or 69. Looking at page 70, we had some discussion. I want to make sure that everyone's clear. It was on paragraph 2 that starts false allegations of sexual assault. And we discussed that in the body of, and I think Ms. Garvin highlighted the fact there should be, it should be consistent with what's in the body of when it refers to sexual assault, false allegations of sexual assault. And I think, but I want to be sure, I think that we said it could be with the apostrophe on each side of that sentence or not. Quotes, I mean.
And weren't you going to rename it consistent with paragraph 1, inconsistencies in?
Inconsistencies in defining, quote, false allegations of sexual assault.
Is everyone comfortable with that technical change?
Yes, all in favor?
Yes. Yes.
Judge Grimm?
Yes. Yes.
Okay, that's unanimous.
Yes.
All right, there was no changes on 71. If we look to page 72, if you could go to tab 7. And these are charts that deal with the incidents of collateral misconduct. So what you see in table 1 is broken down by service, and then what type of action was taken. And then further in table 2, it's also broken down by service and then the type of alleged misconduct, and also broken further down into the number for each type of collateral misconduct, and then as a percentage of the total of collateral misconduct.
Is there somewhere where we explain the difference between quote, accused, unquote, and accused underlined, as we use in table 4.1?
Could you say that again, sir?
Okay, in table 4.1 in the left-hand column, the second one down says number of service members, quote, accused, unquote, of collateral misconduct. Same in the third one down, but the fourth one down says accused underlined, and the next one on the next page, which I guess is the fifth one down, says accused underlined. So we have a tie score, 2 with quotes and 2 with accused, and I'm wondering, do we mean something different? Is that why we did that? Do we need to explain it, or? There must be a reason.
Doesn't seem that it matters much which way it is. It should just be consistent across the table.
I think I can explain it. The reason it's accused in quotes in the first 2 is because that's the way the term was used initially in the report. And then it wasn't carried through, and it was underlined in the next 2 because the next 2 are just giving the percentages of first just the accused, and then second the accused who receive adverse action. So it was for emphasis. So I would suggest either we can take it out of, there's nothing wrong with either just taking it all out or making it all one way or the other.
And it's a quote the first time. The body of the report explains that accused, of course, is a technical term in the military. So the services define that differently for purposes of providing numbers, so it was less than helpful.
So it's not important, other than however, for consistency, you want to put it in the
Thoughts on
charts.
that?
I think the quotations are relatively important in light of the disparate definitions. And so for consistency, if it could all be quotes, I think that triggers a recognition of disparate definitions as opposed to underlined, which is pure emphasis.
That's administrative, we don't need to vote on that, that's fine.
I have a substantive question on table 4.2, false report. I think we also need to indicate, because as it reads, it would read like what one would think is a false report, but based on the inconsistent definitions. I don't know if we just footnote that table back to the page where we talk about it, or if you need to put it in quotations. It says as defined by each military service, but even the footnote maybe would just...
You want it in quotation?
Or just the footnote back to where you talk about it in the report.
Jen, just out of curiosity, it calls it false allegations, and then this says false report.
I know, but I think this is the same date, unless this table is different data, but I don't recall hearing any testimony about a true false report, a clean false report.
When we were going through the collateral misconduct report, the drafts that we received from the services, and then we brought that to the attention of the committee, you all discussed that, you know, their definitions of what a false allegation, a false complaint wasn't clear. And I recall if a victim made an allegation and then there was a cross complaint, remember that discussion? You know, there was some...
Or some if a third party made it and then the
Right.
victim said it wasn't, that was a false report.
Right, and so based upon what you all discussed, we decided to not include that as collateral misconduct because it wasn't clearly defined.
So then this thing in there is a true false report in that table?
No, I think it's as each service defined it,
Defined
which was
it,
very different. I think we also thought that if it's a true false report, it's not collateral misconduct, it is misconduct.
Right.
So that's why I think we're not including them, counting them.
But I see, am I missing something? Because it's in the table. Right? I mean, it's in that table.
It depends on how you want to capture that information. What you decided that it wasn't, as the chair said, it really wasn't collateral misconduct. And then there really wasn't a clear definition what that meant across the services. And so the decision was made that you all would not put it in the collateral report as, collateral misconduct report as collateral misconduct, but you would note, which we did in the false allegation paragraph we talked about. So we could either leave it in if you think it's helpful, or just delete that section right there in the graph.
It seems to me since we're not counting it, we could probably just delete that last block. Thoughts? Delete the last block, favor?
I say delete it.
I'm sorry?
Delete it.
You
Okay.
Judge Grimm?
I agree.
So that passes with Ms. Tokash dissenting. Oh, I'm sorry, I thought you said she dissents.
She said delete it.
Oh, okay.
I said delete it. I agree.
And
That passes unanimously.
I believe the paragraph 2 on page 70 fully discusses your concerns that you had, so I don't think it's, based upon that, I don't think it's relevant. Any discussion on table 3? And that's just a breakout of what was the result of the collateral misconduct versus what they received as a result of committing collateral misconduct.
Any opposition, thoughts, comments? Okay, moving on.
And then the next chart is a pie chart. I don't know whether this is helpful to you all or to the reader, but that's something that you can...
This is the exact same information as Table 1. So the question for you is, do you prefer Table 1? Do you prefer this Table 1 or the first Table 1, or do you want to put them both in, is also suggested? It's just two ways that the graphic designer presented the same information, so.
Personally, I find the pie chart with the wedge coming out very confusing, but that may just be me, so I defer to the committee as a whole.
My recommendation is you go with Table 1, not the pie charts, because it's consistent the way the other charts are laid out by service.
Yeah. In favor of the table, not the pie? Judge Grimm, Ms. Tokash?
Yeah, I mean, you can have your pie, but you can't eat it too.
I agree.
Okay, unanimously passed.
Go to page 75. There were no edits there. Page 76, 77, 78, 79, 80, 81, 82, 83. And that ends the collateral misconduct. Chapter 5, military installation site visits and member observations of sexual assault court-martials in 2020. Chapter 5 is just a chapter we added in here to discuss the site visits and the court-martial observation. So we're on page 84, and there was a staff edit on page 85 where we took out the dates when we would be going to those places, and we discussed that yesterday, and that seemed to be what everyone wanted to do, is just take the dates out, and the staff edit was approved. And then we looked, page 86, no changes. And that brings us to the end of the review of the draft report. And at this time, I believe the chair can take over, and we'll have a vote on the acceptance of the report that as amended with your amendments and changes.
I so move that we accept the report.
Second.
All in
Second.
favor?
Aye. Yes.
Yes.
Okay, unanimous.
Okay, ma'am, what we'll do next as a staff,
Wait, time out. I just want to say on behalf of all the members, thanks to the staff for putting this together. I don't believe we wrote
Absolutely.
1% of this or less, point something percent, even with all of our edits. And so I thought it was another great job for another year, and I recommend that your contracts be extended for another year.
Thank you.
Great.
Well, you don't realize how much you did help, because what we do to write the report is we go back and look at the transcripts and the conversations that you all have had when you're discussing these issues. And so you'll look at the footnotes and you'll see where you're footnoted, and a lot of what the information contained is stuff that you said and did. So I think that so then the way forward, the staff will make those changes. We will get that all out to you, just so you are, you have a comfort level that we did make the changes. And then we will send that to the printer and out to the various organizations that get the draft report. Secretary of Defense and the members of the Senate Armed Services Committee and House Armed Services Committee are the folks that get this. So while I'm up here and I don't have to move, I just want to let you know what's going to happen on the 18th. The chair is having an office call with the Secretary of Defense. So she will have the opportunity to discuss the fine work that you all are doing as a committee. He's received some read-ahead materials to brief him on what you all are doing and some talking points. So that's going to happen on the 18th. And part of the 2020 NDAA, which Colonel Flom may talk about, is that the DAC iPad has been extended for 5 years. So that requires decisions on your part, and we'll get back to you, individually as to whether you want to continue in this excellent mission to make the military justice system better. So that will be forthcoming. But if you want to, are willing to, and what's good about this is you all know what the time involvement is. And so, and now I know some of you are retiring, and you'll even have more time to involve yourself with this worthwhile goal. So the staff would like to thank you for your input and the ease it is. Really, the ease working with you all is amazing. I came in at the tail end of some other committees where they didn't have the cohesiveness and the discussions that you all are having. And that's vital for the staff to be able to work and put together a product that that you all are vitally important to help us do that. So thank you once again, and we're not done for today, but oh yeah, you voted on the report.
Yes, we did. The only, depending on the date of the transmittal letter to the Secretary of Defense, there would be one other edit in the introduction where you have to insert the word former if it's after March 20th. If it's before, you're aces.
Yeah, I don't know if you are all aware, but I don't think she'll mind me telling you that the chair is retiring after 40 years in the Manhattan DA's office. And so once again, she'll have a lot of time to fly around the United States and observe court martials and site visits. So we'll make that edit when we go final.
As needed. We're scheduled for a break, but we've really only been back for an hour, so if people don't mind, why don't we forge through with Mr. Hines and the site visit?
Good afternoon, members. This will be a brief update. I'm not going to rehash what we covered at the last meeting, just to let you know that the site visit planning is proceeding. The staff is putting together question packets on the various topic areas that you will be questioning the practitioners and the various stakeholders that you're going to meet with on the trips. We have at least 4 committee members now going on each trip, which is very good, a very good participation rate. So we're very appreciative of your willingness to take time out of your busy schedules to go on these trips. And we've been working closely with our service representatives to line up our local points of contact on the ground, on site, so that we can facilitate, our movement, do all those little logistical things that people don't think about. And the service representatives have been very responsive and very good at giving us the names of those people on the ground. And that's a continuous process, and we'll proceed as we go through. So unless there are any questions, that's really the extent of my update. Everything's proceeding fine. We haven't, actually, there was one development that I should probably let you know about. The Navy did notify us that that portion of the Europe trip that includes meeting with the Navy, as we had the trip set, the Navy folks were going to have to drive 7 hours to meet us. And so what we decided was we were going to ask them to do that. So that group's going to go ahead and go on down from the first installation down to the Navy, because at Naples they have a very robust, not only operational presence there, but legal presence there as well. There's a RILSO there. That's where the Navy judge in theater sits and has their courthouse. And that's about it. Are there any questions about any of the site visits? I know that I've talked to some of the members, including Ms. Cannon, about your personal travel, and that's something we can talk about and handle. She's not the only one, but we can handle offline with our staff, and that's how we're going to.
What is Glenn, what's the process for determining what questions we're going to ask each particular group if we're going to do this? I thought originally we were talking about the idea of coming up with like 5 questions for the trial counsel, 5 questions for the defense counsel, 5 questions for each group that everybody would ask. So when we got back and you guys compiled it, you'd have answers from across the board. And so the question then is, out of the 50 million questions we could ask trial counsel, for example, what are the 5 that are the most important to us to make sure we all ask? So I just wondered if we have a process to figure that out.
Yes, sir. So, yes, sir. We're as a staff are working on that issue right now and have been working on it. And it's just a process of soliciting everyone's ideas so that we can come to what we call question packets, which was very similar to what we used with the judicial proceeding panel. And those tend to get refined after you do a couple of site visits. You find that there are some questions that are maybe better than others, and some topics that are more robust for discussion than others. And so the staff is working on that, and it's our intent to route that around to get your input so that we have a final product when we get out there. I've also had discussions with Dr. Wells about because there has been there's a concern presented that you need to make this as objective a feedback as we possibly can. So we've been talking with Dr. Wells on how to refine the questions and even use instructions that are part of every site visit, so that when you get that information back, you can put it in a form or a format that's more objective and less susceptible to being called anecdotal, if you understand. Does that answer your question, sir? Yes, ma'am.
I didn't understand what you meant about Europe, since there are 2 locations in Europe. One is Germany, one is Italy.
Yes, ma'am. Good question. We had such positive response on that particular trip that we determined with the staff director and the deputy that we were going to not have everyone go to both sites. And so we've got basically half of the members going to Germany and half going to Italy.
So when they come back from Naples talking about the Admiral's Villa that they had their meeting in, overlooking the bay and Capri and everything, you're not going to be on that one. You're going to Germany.
For that site visit for the Italy, if you signed up for that, if you signed up for the site visit to go to Italy, that 7-hour trip that Glenn was talking about will probably fly, but that's going to take an extra day of travel, which we didn't anticipate doing. So I would look at your calendars and make sure you have the additional day or 2 to make that trip, because one of the things we're trying to do on these site visits is make it a little as possible impact on the units we want to talk to. And clearly having folks drive 7 hours is not. So we're going to just travel all day and then get those folks the next day so that we're not impacting them.
And I don't think it's not going to cause, shouldn't cause too much problem, because that trip is the week of July the 26th, and it was already scheduled to end on Thursday. And so if we had to add one more day, it would still be, it wouldn't be going over or into the following weekend or the following work week. Any other questions on the site visits?
Glenn, I just had one. In addition to developing the questions that we want to present, have we identified specifically which components of the system that we're, who are we going to talk to in particular, what disciplines they are, and that we're going to have a representative sample of those at the sites?
Yes, Mr. Markey. So each day will have, much like our public meetings or our prep meetings, there will be an agenda that we prepare, and then in addition to the agenda, each of those sessions will be with a different, the term I use is stakeholder. So trial counsel will be in one session, defense counsel in another, VLC, if we meet with the VLCs, investigators, commanders, convening authorities, and the two training bases, there will also be a period where we're going to meet with recruits or trainees and entry-level training. So we're working with the service reps to make sure that we get the right people for each panel, but we also get a sufficient number of them, and hopefully a sufficient number of them with the requisite level of experience that'll be of the most value for you when you're speaking with them.
Thank you very much.
I just did. Could I ask another question? Just one follow-up on this, on the trips. Would it be possible to have you circulate a little chart, perhaps, that has the dates of the trips, the people that you have as indicating a desire to attend, and maybe a point of contact if the individual members have some questions about travel arrangements, to get some background information. Some of us, myself included, our schedules may have shifted as a result of work exigencies that created situations that didn't exist before, and I just want to have the most recent information about these site trips to confirm availability, if that's possible.
Yes, Your Honor. If I heard you correctly, were you just asking about the current schedule of when the trips are and which members and which staff are going to be attending each trip?
Correct. And then maybe a point of contact so that if we have questions about travel arrangements, for example, we could contact and get some information on that.
Yes, sir. Our staff will be putting together your travel, so I'll absolutely get you that information as soon as possible.
Thank you so much.
You're welcome.
Thank you. Unless anybody minds, why don't we forge ahead, which would be Colonel Flom with the 2020 NDAA.
If you wanted to hear just a very, very brief update on your court-martial observations, I can provide that.
Great.
Yeah, the court-martial observations are still ongoing. Holidays slowed us down a little bit, but we had 2 more members attend court-martials since the last meeting. We are now into some of the members attending second court-martials of a different service, and everyone is finding the experience very valuable. I just sent out a list of over 80 court-martials that are sexual assault court-martials scheduled to take place between now and really June. And some people have already responded with the dates they may have available. If everybody else can take a look at that and just get with me on that. There's no questions. That's it.
Thank you.
Thank you.
Colonel Flom, welcome.
It's on. Thank you very much. It's great to be back. If you recall, I testified before this group back in August as part of the initial hearings that we conducted back in August. But by way of introduction, I'm Colonel Pat Flom. I'm the Chief of the Criminal Law Division for the Office of the Judge Advocate General for the United States Army. And I've been asked to provide an update or sort of an overview on the key provisions of the 2020 National Defense Authorization Act. And I'll hit several items that of course, impact this body directly, and some of which have already been mentioned in the earlier hearings, but also some other provisions that are in the Act that may be of interest to this group as it looks at the investigation, prosecution, and defense of sexual assault in the armed forces. For the, I guess, the larger audience, I won't, of course, hit every item that's in the 2020 NDAA. It's a comprehensive document that is, of course, it's the 1,000-page statutory provisions that provide the authorization for the Department of Defense writ large. These are only the provisions that basically address military justice and specifically sexual assault in the armed forces. So with that, next slide. The first section that is worth noting is, of course, Section 535, that extends the DAC iPad from its initial 5-year charter to 10 years. So congratulations, you've been extended until 8 February 2026, where previously the expiry was 18 February 2021. The next item of interest is Section 550 that actually appoints a new Defense Advisory Committee. This one is the Defense Advisory Committee on the Prevention of Sexual Assault. This charter of this committee is that it shall advise the Secretary on the following: the prevention of sexual assault, including rape, forcible sodomy, other sexual assault, and other sexual misconduct involving members of the armed forces, and as well as the policies, programs, and practices of the department as it relates to the prevention of sexual misconduct. And so the key note here is that there are, of course, going to be matters of joint interest with both of these bodies, and the statute actually requires coordination between these two separate defense advisory committees. Next slide. The next section that is important and specifically addresses the DAC iPad is the requirement to conduct an assessment of racial, ethnic, and gender disparities in the military justice system. So this statutory provision actually has two portions of it. The first is a task to the Department of Defense, and it requires the armed forces to record the race, ethnicity, and gender of the victim and the accused. It also requires the department to gather any other demographic information about the victim and the accused as the Secretary determines to be appropriate. And then it also requires the services to include this data in a report that the armed services each produce each year under Article 146 Alpha that basically records the data of courts-martial each year. It's been called, colloquially it's called the CAF report, but now it is called the Article 146 Alpha report. But then that will then drive a task to the DAC iPad, which requires an assessment of three things. Two of them are listed here on the slide, but a review and assessment by fiscal year of the race and ethnicity of members of the armed forces accused of penetrative sexual assault or contact sexual assault offenses in an unrestricted report. Then the next is the same assessment, review and assessment by fiscal year of the race and ethnicity of members of the armed forces against whom charges were preferred. And then the final task that's not listed on the slide but is in the statute is an assessment of the race and ethnicity of those members of the armed forces who were convicted of a penetrative sexual assault or other contact sexual assault offenses. And then it requires a report from the DAC iPad informing the Secretary of the Defense and the House Armed Services Committee and the Senate Armed Services Committee, setting forth the results of those reviews and assessments. And again, the portion of this provision is to record this data and then determine if there are any disparities that require action by the Department of Defense or by Congress. Next slide. Outside of the statute, there are two tasks. There are actually three. I'll address the third a little bit later, but General Schwenk brought it up earlier today. But there are two assessments in the conference report to the National Defense Authorization Act. So this is outside the statutory language, but it's included in the report of the conferees from the HASC and SASC on the National Defense Authorization Act. And the first is a task to the DAC iPad to conduct an assessment of other justice programs, for example, mediation or restorative justice programs that might be appropriate to assist the victim of alleged sexual assault, particularly where that sexual assault may not have proceeded to a criminal prosecution. So in essence, an assessment of other programs that might assist victims in the process. The next is an assessment under RCM 1001C of victim impact. So as you may already know, and of course General Schwenk brought this up earlier, RCM 1001C affords victims a special right to provide input to the court-martial with respect to two items: victim impact and also mitigation. They can do this in one of two ways. They can do it through a sworn statement or an unsworn statement. And the conferees are concerned that some of the military judges have interpreted this rule too narrowly. And as a result, it's limiting what survivors are permitted to say during sentencing hearings in a way that doesn't fully inform the court of the impact of the crimes on the survivors. So what the conferees have asked the DAC iPad to do is to conduct their own assessment as part of their review of courts-martial cases to determine whether this may be the case. There's also a third task in the conference report that's related to guardian ad litems, and I'll talk about that a little bit later with respect to a separate study the Department of Defense has to conduct with respect to guardians ad litem. Next is a series of provisions that do not have any specific tasks to the DAC iPad but may be of interest, and these result to victim notification. And so the first is Section 536, that is a special statutory provision that requires the DoD to establish procedures to enable the return of personal property that's been collected from a victim as part of a sexual assault forensic examination. And so currently, those procedures may not be as clear or as formalized as the statute would, or as Congress would like, and so they've directed the Department of Defense to establish procedures by which a victim can seek return of personal property, and also to making sure that they're informed perhaps of the consequences that the collection of that personal property may have on their case. Next is Section 538, which requires the notification of the victim of each significant offense in the prosecution of in the military justice system, or the military justice process, and the processing of their case specifically. It requires two things additionally. It requires documentation in the case file of the victim notifications, and also it specifically also requires a documentation of a victim's preference, whether they prefer their case to be handled through the military justice system or the civilian system. Next is it requires status updates, specifically as a case makes its way through the system. And so the commander, as the commander who is making determinations, they must periodically notify the victim of the status of a final determination on further action on their case. So basically, again, it requires status updates to the victim on the case as it proceeds to final determination, whether that final determination be court-martial or non-judicial punishment under Article 15 in the Uniform Code of Military Justice, another administrative action, or no action at all. So again, statutorily requiring victim notification. Next slide. The next two sections that I'll address, I've consolidated them into sort of one bullet, but two sections that basically by statute, increase the manpower allocated to the investigation and victim assistance in sexual assault cases. And so the first is a requirement that military criminal investigative organizations increase their number of defense forensic examiners by at least 10 over about the next by at least 10 since the number that was in existence on 30 September 2019. So a statutory increase of 10 defense forensic examiners. Next is an increase in number of sexual assault investigators. And so that the statute doesn't prescribe a specific number, but what it does prescribe is a standard. And so the standard is that the military criminal investigative organizations are to have enough investigators such that they can process their cases to the extent practicable within 6 months from the report, or I should say the initiation of the investigation.
Colonel Flom, excuse
Yes,
me,
ma'am.
can you just clarify, the MCIOs will increase the number of defense forensic examiners or digital forensic examiners?
I'm sorry, you're exactly right. It's digital forensic examiners.
Okay,
Yeah,
two different
DFEs.
things. Okay.
Yep, I misspoke there. Thank you, ma'am. Finally, it requires an increase of victim witnesses, VWLs, victim witness liaisons, across all the services. In essence, the services are directed to fill all of their shortages. So there may be allocations out there that aren't filled for one reason or the other, and that the services are required to fill their shortages by 19 December 2020. Next is Section 540C that requires the Secretary of Defense to establish a policy to ensure timely disposition of sexual assault prosecution decisions. Most importantly, a decision not to prosecute a particular case. And so that policy is required by June of 2020. And again, the policy is designed to ensure timely disposition of those non-prosecutable sexual-related offenses. The next three sections that I'd like to address training. And so these three provisions are statutory provisions that direct the Department of Defense to conduct specific training. The first is to initial disposition authorities, so IDAs. So statute requires specific training for initial disposition authorities, and those are the authorities that were established in an April 2012 withholding policy from the Secretary of Defense. So you may be familiar that the Secretary of Defense withheld disposition of certain types of sexual assault, certain types of sexual offenses to 06s with the Special Court-Martial Convening Authority power. And so this requires specific training for these initial disposition authorities that basically is designed to train them on the exercise of their disposition authority. Next is Section 540B, which directs specific training on the role of commanders in the military justice system. And so commanders across all the services are instructed to, or are required to receive uniform training on the role of commanders in all stages of the military justice process. That training is to include investigation, prosecution, victim and assistance rights, retaliation prevention, healthy command climate to facilitate reporting, and any other matters that the Secretary of the Defense may deem as appropriate. That training is also required to include best practices, and the department is also required to conduct periodic surveys to identify those best practices and then again incorporate them into the training. And again, all of the services are different in terms of how they train their officers and their commanders, but the statute requires the Secretary to ensure, to the extent practicable, uniformity across all the services. Finally, is section on this with respect to training is Section 540D. The Secretary of Defense is to establish and develop and issue a comprehensive policy to reinvigorate the prevention of sexual assault. And so this is complementary to the Defense Advisory Committee that the statute creates. This also directs the Secretary to establish policy to reinvigorate prevention. And so that's, the policy is designed to include education and training and programs designed to encourage and promote healthy relationships, empowerment of non-commissioned officers, fostering of social courage to promote intervention, processes and mechanisms to address behavior on the continuum of harm, prevention of alcohol abuse, and any other matters that the Secretary deems appropriate. And so within 180 days after the issuance of that policy, so that policy is required by 17 June 2020, within 180 days after that, the secretaries of each of the services have to have their own policy. Next slide. These next three provisions are those that I best categorize as affecting the prosecution of sexual assault. And so the first is Section 540J that requires a pilot program for defense investigators. You heard that mentioned by one of the panel members earlier. The statute requires each of the services to conduct their own pilot program. There are two specific aspects of those that are worth mentioning, and the first is that the programs are supposed to be as uniform as possible across all of the services, but also, too, by statute, it requires that a defense investigator may not speak to a victim of an offense except through a request made through the Special Victims Counsel or another counsel if the victim does not have their own Special Victim Counsel. So that is one sort of aspect of the program that as the services are conducting their pilot programs, that will be required as a part of this new statute. And then after the pilot program, the statute requires a report after 3 years on those. And I will note that the Army has already begun a program to institute defense investigators, and it will hire 12 and it's in the process of hiring 12 right now. Next is Section 543, and so Section 543 amends 10 U.S.C. 1567 alpha. So I apologize, and I'll send a corrected copy back, but it's 1567 alpha, subparagraph alpha. And so what Section 1567 alpha does is require notification to law enforcement, to local law enforcement, when a commander issues a military protective order, when either the victim or when either party, I will say, to the military protective order lives off of the military installation. So it requires notice. This provision requires that notice or that notice to take place within 7 days of the issuance. It also establishes a reporting requirement that the services will track the number of military protective orders issued and the number that are reported to civilian authorities. Section 550 is an additional provision to protect disclosures that are made as part of the catch a serial predator or catch a serial offender program. So this is a program under the Department of Defense whereby victims who have made a restricted report can still provide details with respect to their offender or the offense to law enforcement to enable the investigation of serial offenders. So this provision provides two protections back to victims who choose to participate in this program. And the first is that anything that a victim says as part or discloses as part of this program is protected from disclosure under the Freedom of Information Act. There is such a program now, yes. It has been started. I don't recall the exact specific date, but it is in effect right now. Next is Section 550 also makes clear that anything that a victim says as part of this disclosure with respect to this program does not affect the status of their restricted report. It, again, protects their restricted report even though they choose to participate in this program. Next slide. So this is Section 541. So these provisions address basically the victim, let's say, legal counsel that's provided to victims. So first, Section 541 it makes clear that Special Victims Counsel or Victims Legal Counsel must assist, consult, and assist victims with incidents of retaliation. So they are to assist victims in understanding their rights, assist victims in filing any complaints, and also assist victims through any other resulting military justice proceedings. This provision, Section 541, also directs by 20 December 2024 that staffing levels for Special Victims Counsel or Victims Legal Counsel are such that, to the extent practicable, the average client load is 25 cases for these counsel. Section 542 mandates that a Special Victims Counsel or Victims Legal Counsel will be made available to a victim within 72 hours of notification, 72 hours of the request absent exigent circumstances. So the statute gives authority to the secretaries to articulate what those exigent circumstances are, but basically, again, mandates that the Special Victims Counsel be available within 72 hours. And if the secretary determines that a victim's legal counsel cannot be available through within that 72 hours, that the secretary ensure that the counsel be provided to the victim as soon as possible. Section 548 is a new statute, and I'll address this also later in the reporting provision. But what this does is expand the availability of counsel to domestic violence victims. And so as long as the domestic violence victim is otherwise entitled to legal assistance under 10 U.S.C. 1044, that's the statute that authorizes legal assistance, they would also be entitled to counsel. That leaves to the services, the ability to determine whether that will be provided out of the services legal assistance function or the Special Victim Counsel function. However, what it does also require is a report back to Congress, actually coming up very quickly, within 120 days of the passage of the statute, which would be in April, on how the services are going to implement this, what resources they may need, what training or other statutory provisions may be necessary to expand and to make this program happen. But it also specifies that these counsel are to receive special legal training in the legal issues commonly associated with domestic violence offenses, and also, too, that it directs, to the extent practicable, that they serve as counsel in this role for not less than 2 years. It also makes clear that this relationship is to be an attorney-client relationship versus some other type of relationship. Finally, Section 550C makes clear that when a counsel is assigned as a Special Victim Counsel, that they're to receive special training on the local laws that are applicable in the jurisdiction in which they practice. What this is designed to facilitate is the educated and informed advice that they may give to a victim on whether to choose, whether to elect the handling of their case through the military justice process or through the civilian jurisdiction. And so that training it must include victim rights, prosecution of criminal offenses, sentencing for conviction of criminal offenses, and protective orders. Again, the local laws that address those 4 items.
Can I just make one comment
Yes,
about that? It takes a fair amount of time to learn all of those things about a local jurisdiction. People get transferred from installation to installation. Just also note, you could have soldiers in Fort Dix come to Manhattan for the weekend, so knowing New Jersey law, to the extent you can learn it that quickly, is really not going to help you very much. I think it's well-intentioned, but it's not an easy task, is all I'm trying to point out there.
Yes, ma'am. Thank you very much. No, and I think it will be incumbent on the services to look at those nuances of this election and make sure that we tailor our programs appropriately.
Sir, if I may, just a quick question also. That training on the law and policies with regard to the state systems, that doesn't expand the SVC-VLC's role to representing in those systems, does it? It's just if the survivor the victim goes that route and prosecution is that route, then the SVC and VLC is not representing in that system still, correct?
That's right. I do not, yes, I do not read it that way. That, again, it's solely to assist the Special Victim Counsel in advising their client in making an informed decision as to which process to choose. Next slide. The next 8 provisions over the next 2 slides are reports that the Department of Defense is required to provide back to Congress on various aspects of the military justice system. And so the first one is a recommendation as to the establishment of a separate sexual harassment punitive article. So currently under the military justice system, sexual harassment is generally punished in one of 2 ways. I'll say addressed in one of 2 ways. The first is through Article 93 of the UCMJ, which is a provision that prevents cruelty and maltreatment to subordinates. The second way is through violations of any applicable service regulations or policies that address sexual harassment. What this provision is asking the Department of Defense to do is to provide an assessment on whether, for lack of a better word, the pros and cons, the issues involved in an actual separate UCMJ article that would address sexual harassment. Next is Section 540F, and I think, if I may editorialize, I think that this is the most significant study that the Department of Defense has to conduct, both in scale and in consequence. But what this is an assessment of the feasibility and advisability of an alternative military justice system for felony-level offenses, where an 06 judge advocate with significant criminal litigation experience outside the chain of command of the accused makes preferral or referral decisions. So that is a very comprehensive study that also, by the statutory terms, requires an assessment of other military justice systems throughout the world. That is, the Department of Defense has been given 300 days to conduct that study. Next is Section 540H, and this is the study to assess the feasibility and advisability of establishing or expanding a policy that's currently applicable only within the Air Force with respect to what's called safe to report. And so what this would is provide immunity to victims who may have engaged in collateral misconduct during or predicating their sexual assault, or also if there was collateral misconduct discovered within the investigation of the sexual assault. What this provision would do would be to provide immunity to victims who report with such collateral misconduct. This, of note, though, a bill has been introduced in both the House and the Senate within the past 2 weeks that would create this provision by statute. Next is Section 540, and that will be considered as part of the 2021 National Defense Authorization Act. Next is Section 540K, and the purpose of this study is to conduct an assessment as to the feasibility and advisability of expanding the protections available to victims who make restricted reports. In other words, when a victim makes a restricted report, they can only make that restricted report and have it remain restricted to certain individuals. What this requires the Department of Defense to assess the feasibility and advisability of expanding that. In other words, victims could make restricted reports to other particular members. For example, one of the questions by statute that were asked is whether they might be able to make a restricted report to law enforcement. So they make a report to law enforcement, but say that they want the report to be restricted, and also to members of their chain of command or a military sponsor. And so again, they could make those reports and they would still be considered restricted for purposes of that policy. I'm sorry? Or, yes, and the third party, as I understand the statute, is that if a third party were to report a sexual assault, that the victim themselves isn't reporting, the third party's making that, then the victim could still ask that be a restricted report. Next, and what's important also on this one is that as DOD is conducting this study, that DOD is required to consult with the DAC iPad on this. That report's due in June of 2020. The next is Section 540 Lima, and what this provision asks, or what this provision asks DOD to study, actually it asks both DOD to study as well as the DAC iPad to study the feasibility and advisability of establishing a guardian ad litem program. And General Schwenk, you mentioned this earlier in the discussion with the judges. The military, the DOD study is basically limited to determining whether a guardian ad litem program would be appropriate for military dependents who are victims or witnesses in a crime under the UCMJ. So that requires a couple things by the statutory terms that we're asked to look at is what if the victim is under 12 or if the victim has a mental impairment or incapacity in some way, shape, or form. The next, what the DAC iPad, though, is required to study. And by the way, I will say that the DOD has a year to provide our study. The DAC iPad only has 6 months to conduct its study. But what the DAC iPad is directed to study is the advisability of providing a guardian ad litem for upon the report of any sexual related offense for any victim who's not attained the age of 18. So it would be a much broader, sort of broader group of folks that would be entitled to a guardian ad litem under the department or under the DAC iPad study.
May I ask a clarifying question? The DAC iPads, though, is just victims, not witnesses, and DOD is victims and witnesses?
That's the way I understand it.
Okay.
Yes, ma'am. Next is 540M. This is not a Department of Defense study. It's actually a GAO study, but it is noteworthy that the Congress has tasked the Comptroller General of the United States. Again, likely it would be the GAO that conducts this study, but it's a report on the implementation of the statutory requirements on sexual assault prevention and response in the military over the period of 2004 to 2019. So this is again a very comprehensive study governing 15 years worth of statutory and policy changes that have occurred in the sexual assault arena during that time. Section 542 directs a study on the feasibility and advisability of establishing and maintaining civilian positions to support special victim counsel or victims' legal counsel. And so in those services that don't have by policy civilians assigned to, in essence, as paralegals or other legal assistants to help their victim legal counsel or special victim counsel, this asks a study as to whether that might be appropriate to maintain continuity of representation in the representation of victims, and also the preservation of institutional knowledge when it comes to assisting victims in this capacity. Next is Section 548, which I mentioned earlier, but again, to the extent that, the statute does require the services to provide counsel to domestic violence victims. This requires the services to report, and well, actually DOD to report how the services are going about the implementation, any additional resources that might be necessary, and any additional law or policy changes that are required to implement that. And then finally, I'll end with the mention of the change to Article 37, and that that section was previously called unlawfully influencing the action of the court. Under the new statutory title, it's called command influence. This is the most significant change to the unlawful command influence law, unlawful command influence statute since 1968. There's been quite a bit of case law that's evolved since then, but it's the most significant statutory change. A couple key points from this that are worth mentioning for your awareness is that it now protects preliminary hearing officers and special victims counsel has been previously, I won't say excluded, but not specifically mentioned in the statutory protections against unlawful command influence. And it provides two significant expansions that had previously not been included in the statute. And the first is it allows for expressly authorizes statements regarding criminal activity and offenses that do not advocate for a particular disposition or a particular court-martial finding or sentence, or do not relate to a particular accused. So in essence, a commander could talk about, it authorizes commanders to talk more freely about criminal offenses in their formation with the intent to dissuade or deter those types of offenses. Makes clear that that in and of itself is not unlawful command influence.
So this puts into statute the old crimes not criminal, crimes not criminals, process not results.
Yes, you may have heard it as lawful command emphasis as the counterbalance to unlawful command influence, but yes, sir, I think that's accurate. Next, it also allows more, it also specifically allows more communication between superior and subordinate authorities in discussing military justice matters, as long as the superior does not direct a specific disposition or substitute the subordinate's discretion. So again, allows a subordinate to seek counsel and mentorship, but still protects a case from a superior commander directing a particular disposition. The next major expansion of this article is that it requires an accused to show prejudice to receive relief. In essence, the violation must materially prejudice a material right of the accused in order to obtain relief under Article 37, which is, again, a change to the current state of the law. And so with that, I appreciate your patience. I ran through a number of provisions of the 2020 NDAA. I hope it wasn't too dry or too much of a recitation of the statutory language. But again, I tried to identify those that specifically address the DAC iPad, as well as other provisions that again, may be relevant to you as it addresses the investigation, prosecution, and defense. And I would also say victim support through the military justice process. So with that, I'm able to answer any questions if you have any, or I'll yield the floor.
Yep, I have a quick question. Related to Section 538, notification of significant events, does that include submission of kits, analysis of the kit, things like that, or is this just strictly related to investigatory, like the actual investigation and moving it through the actual process?
I read this to solely address process, as it moves through sort of each step of the process. I don't know if the drafters were thinking of sort of what I would call investigative steps that are outside of the normal flow of a case, but it is certainly a point worth noting.
So USACIL is not considered part of the calculus right now where 538 is concerned?
That is my understanding, but I'm willing to stand corrected if I'm wrong.
Thank you.
Judge Grimm, did I hear that you had a comment or a question?
No, I was just going to say it doesn't sound like Congress is very concerned about this area that we're dealing with. That was sarcastic.
Oh, okay. I'm not sure. I'm sorry, Judge Grimm, did you have a comment or no?
No. I was just observing that there's obviously a great deal of congressional interest in this area that we are looking at.
Okay.
I heard you, Judge.
She has a comment? Megan, do you have a comment?
I don't.
No, that's all right. That's
Okay.
all right. It's too hard to hear. It was just an observation that there's obviously a lot of congressional interest in this area that we are focusing on.
We got it.
Okay.
Judge Grimm, thank you.
And Colonel Flom, thank you so much. I hope you have an enormous wall calendar for all of these due dates, and I hope you don't plan to sleep.
Thank you, ma'am. Thank you very much.
We're just going to take a brief, stretch-in-place break while the staff arranges for our public comment.
A genius must have come up with that. A theoretical math major genius. Did we find out what was going on outside? Zombie apocalypse. Okay. Wow. I hope the female hockey players want to deal this part.
Thank you very much for coming to speak with us. I know you've made a request for public comment, and we look forward to hear what you have to say.
Thank you so much. I realize I'm what stands between you and being adjourned, so I will be brief as I can be.
Take all the time you want.
Thank you. I would like to thank the esteemed members of this committee for the opportunity to be here today before you. My name, as you shared, is Jennifer Elmore, and I am a survivor of sexual assault, military sexual assault, committed by my father, a now retired United States Army Major General. For the past 5 years, I've lived and am still living as a victim through the investigation, the prosecution, and the defense of my sexual assault, first through the military justice system and now through the civilian justice system. Today, though, I'm not here as an individual, but as a representative for a broader group of military sexual assault survivors known as Survivors United. We're a group that has come together to provide a room for voices of victims and their experiences navigating the military justice system. It is because of those firsthand experiences that we are well-equipped and eager to be active participants in creating fair and comprehensive change. We are more than our stories. We want more than just to be told we are sorry for what you've experienced. We want to be as actively sought after and respected for the contribution we can make to improvement, as are so many others, legislators, experts, judges, prosecutors, defenders, who are committed to the building of a system which is fair and functional. One way in which we've sought to participate is through ongoing conversations with legislators on specific concerns, observations, and ideas that are based on our experiences. Last year, we spoke with legislators on specific topic of sentencing and the restrictions placed on victims in that process. The restrictions severely limit what a victim may include in their victim impact statements, as well as how those statements are delivered. Specific experiences we've had include redlining of statements before being given, not being allowed to complete the statement in delivery, being cut off by judges, the inability to say anything about our preference or desire for sentencing. While I have not yet had a chance to give an impact statement, I was close enough in the Article 32 process to have been asked to begin preparing my thoughts. Preparing myself for that moment to sit in a room with my father, look him in the eye, and tell him the impact of his actions was of extraordinary importance. To have been restricted as to what I could or could not have said was a reenactment of the very message of insisted silence of my perpetrator. What we know anecdotally, we strongly believe represents a common experience of survivors of military sexual assault that get to this stage in the process. We do not, however, have the data to support that belief. We hope, as this committee continues to gather informing data in many areas that this specific topic would be included in those efforts. Victims are watching this process. They're making the determination of whether or not it is safe to come forward. Is the process fair? A victim having the freedom to speak freely at sentencing is the one way that they can know, or one way they can know, the answer is yes. In closing, I'd like to share with you the appreciation for various members of Survivors United who've had the opportunity to come before you in the past. Personally, I have experienced the results of the hard work by you and others in hard work for the armed services and making improvements. I did want to share a story of a life experience with the prosecutor in my case. In the first meeting with the prosecutorial team, without my having said anything, I walked into a room and they knew the impact of being in a room filled with members of the armed services in uniform. And they showed up in civilian clothes. It was profound, profoundly kind. By the time we got to the preliminary hearing and I was to go before the judge for the, and be cross-examined and to give a testimony, uniforms were required, and the fancy ones, not the comfortable ones. And I was standing nervously in the hallway, and the Army captain, main prosecutor, came up to me and silently whispered to me with her hand over her Army badge and said, "This is your Army, we choose you." Thank you for the work you are doing to put the broader facts together that allow for real change to happen. We look forward to working with you on an ongoing basis. Thank you. And I'm happy to take questions.
Thank you, Ms. Elmer. Does anybody have questions for her?
So one of the areas that you're concerned about having victims restricted is a specific sentence recommendation, or however specific they want to be. Is another, we heard, remember I asked, I don't know if you were here, but I asked the judges earlier for their thoughts and read them the statute. And one of the other areas they said they had limited the victim's testimony was when there's a piece of evidence that the judge during the trial ruled was inadmissible, and the victim, to the victim, it was a significant matter that they wanted because it helped explain the impact of the offense on them.
Yes.
Is that something else that you think we should look at?
Absolutely.
Okay.
I have a very passionate answer to that, just because the completion of my experience with sexual assault spans over a period of 15 years. And so the totality of those experiences sets the context for any one experience. And so the importance of evidence being admitted more broadly than just what otherwise might make sense is incredibly important, in my opinion, in these cases.
Okay. Do you have any other if you do now know of other categories, that's great. Please let us know what they are.
You shouldn't have asked me that. I have a list of 20 back here.
Well, then could you give us or give the staff a list, and that way there are specific things that we can then talk to people about.
Yes.
We're about to go on site visits and ask people in the field and talk to Special Victims Counsel and Victims Legal Counsel.
Be
and
happy
so
to.
that would help us as we step forward. So
Be very
thank you
happy
very
to.
much for being here.
Thank you.
Thank you for being here. I had a question. You were here all day.
I about halfway through the day, so I missed the judge's testimony.
Okay. The judges told us that they don't give reasons at sentencing for why they have imposed the sentence. They just say evidently a term of years. And I thought both for the defendant who's been convicted and the sentence is imposed, as well as the victim, that they would want to know the reasons the judge imposes the sentence. I'm just curious if obviously from the victim's viewpoint, if you would want to hear the reasons why the judge imposed the sentence, or if just the ultimate sentence.
It is something we've had a lot of sentiment about and have experienced firsthand, and it is very frustrating for there to be silence on either side, whether it's a conviction, acquittal, or for that matter, any judgment that is made. One of our group members, in fact, had a full acquittal in her case and has nothing to point to as to why that was the case, and really is shut down even in asking the question, right? There's no dialogue. So extraordinarily painful. And again, back to my comment about victims watching, I know one of the things that Department of Defense and the Armed Services are focused on are getting accurate numbers of how many, what exactly is the extent of this epidemic, and I believe it is. I believe people are watching, and the facts come together. And for victims that see these things where, you know, I'm going to really put myself out there and incur a huge cost to tell a story, and I know my chances are one direction or the other of there ever becoming a conviction, and then not to have an explanation is very heavy on the side of not saying anything.
Ms. Tokash, did you have a question?
I didn't have a question. I just wanted to say thank you very much for coming in to speak to us today. We really appreciate it.
And this is Paul Grimm, Chair. If you can hear, if I could have one comment to add to echo entirely what Ms. Tokash said. In the federal courts, I know that there are statutory victims' rights that have been enacted by Congress in the last few years, and that it is very frequent to have both written submissions in federal court that are provided in sentencing, and that it is not at all infrequent for me to read from, if not the entirety. Sometimes, unfortunately, I get dozens of them, and reading from all of them is not possible, but to help the defendant understand the impact of the conduct, and also an opportunity to speak in person, and whether or not the victim chooses to do it or not, it has been my personal observation that the ability of the victim to have their experience shared with the defendant is something that is instructive not only to the defendant, but also, even if the outcome is a lesser sentence than what the victim might have hoped for, helps them understand, and I have been enormously impressed by the grace and dignity of the victims under these circumstances, and sometimes, quite candidly, the forgiveness.
Thank you for being here. I believe you mentioned that you testified, if I'm not correct, correct me, but you testified at a 32 hearing?
The preliminary hearing before the
Right.
32, yes.
And how did you feel about that? Because we're looking into questions about that, and we want to know your feelings about
The advice and counsel that I was given prior to the preliminary hearing was that much work had been done to protect victims from having to testify at the preliminary hearing. In this particular case, the advisors, the prosecutorial team felt it was very important for the judge to hear from me in the preliminary hearing. And so it was my choice to either take the protection that I'm afforded or to testify, and I chose to testify. And it was, there's a lot to say. It was extraordinarily difficult, and I've had a vision in years gone by that moment of sitting in a courtroom and being allowed to answer questions truthfully would make a difference and fix something. And it was important, but then to be subject to cross-examination and having judgments made on different aspects of and different activities that for me were devastating, some thrown out, some kept in, and know that my testimony was having a lot to do with what was given validity and what wasn't, was a learning experience.
One of our concerns is if you don't testify at the preliminary hearing and it does go to court-martial, you have no idea, and it's kind of like a blind side in some respects. So given that, I would have been better prepared for the 32 had we made it there.
Okay, thank you.
Yes.
Thank you for being here. It's good to see you. I want to make sure I understood part of your statement. You mentioned that one of the things that some of your members have experienced is, I think you talked about redlining or
Yes.
cutting out, which certainly used to happen in the civilian system a couple of decades ago. But so you're saying some of your members actually have had
Yes.
people redline?
That's correct.
Okay, thank you.
Thank you very much for
Thank you
coming
so
and
much.
sharing your experience. It will be very helpful to us as we continue our work in this area.
Thank you so much. I appreciate it. Thank you.
Colonel Ware, do you have any last matters?
Just want to draw your attention to the next public meeting is May 15th, but I know the working groups have had some conversations about meeting before and in between that public meeting. There's some more work to be done, so the staff will be contacting you to take care of that. Next week, I'll shoot out an email that gives you almost the next year and a half's dates that have been selected for the public meetings, but they're going to fall up roughly in the same months. I just want to emphasize the importance of these courtroom or court-martial observations, because what we envision as a staff, you've heard a lot of information about what transpires in a courtroom. So when you all go out and observe court-martials from different services, and then what we would like to have if not everybody, a large number of the committee that has gone and witnessed 2, 3, 4, how many you can fit into your schedule, and then come back and have a discussion about what you saw, the good, the bad, not specifically pointing out, Prosecutor Weir was horrible, but generally what you saw in those court-martials. I think the members who have seen trials already have a frame of reference when they're listening to what the military judges are talking about, and so I think that's vitally important. Remember, for the site visits, you all can submit questions about what you think is important. So if you are a former high-speed investigator, that would be the person who would submit questions for investigators. So what we will do is gather all those questions up in a format, and it'll be prosecutor questions by the various types of folks we want to talk to, and then we'll try to come up with I won't say one to whatever it is. Number one's the most important, but we'll try to get those questions in some type of order that makes sense as far as trying to make sense out of the site visits. And I think it's important that, as was pointed out by Glenn, that Dr. Wells says these site visits can have research analysis can be done on those questions. And so it would make sense to have all the same questions asked or refined as we go to various installations. Ma'am, that's all I have. Oh.
Just for planning purposes, the site visits, you have them listed for 3 days. Is that 2 days of travel and 1 day of site visit, or is that a 3-day site visit?
That's including travel.
Including travel. Thank you.
Do you really?
Sure, yeah.
Thank you. I appreciate it. Tremendous amount on this, and I'm very appreciative. Don't worry about it.
And that wraps up this day-long meeting of the Defense Advisory Committee on Sexual Assault in the Military. If you missed any of our live coverage, the entire event is available to view online at cspan.org. Just type Defense Advisory Committee on Sexual Assault in the Military in the video search box at the top of our homepage.
Follow Campaign 2020 to Nevada this weekend. Saturday night, live at 11 p.m. Eastern. Democratic presidential candidates Joe Biden,